Welcome to SST College of Arts and Commerce. This is SST Edupedia. Myself, Assistant Professor Sunil Shah. Today I would be covering up the topic called Rules of Private Placement given under Companies Act 2013, and this is in the subject called Business Law of SYBAF and SYBCOM SEM 4 of Bombay University. Students, you are aware when the company wants to generate revenue, they would be generating revenue in the form of shares, or would be coming out with the debentures, or would be going through the public deposits. Otherwise, if they want the finance, they would be taking the loan from the banks or any of the financial institution. But now the procedure is something different under the Companies Act 2013, which is the guidelines which is given under Rule 14 of the Companies Act. Our private placement is a sale of securities to a small group of persons or a select investors as a way of raising the capital while avoiding key disclosure requirements, which is much more tedious process when they want to come out with the shares. The target investor audience for private placement deals are aggregated investors whose net worth exceeds rupees 1 million, and the institutional buyers like large banks, mutual fund, insurance companies and pension funds. Both public and private companies can either sell equity shares or bonds through the private placement while taking the advantage of the some key benefits, that is the cost as well as the time. Today in this particular video I will be speaking only about the rules which are governed under the Companies Act. Rule 14 Part 1. Prior to the approval of the shareholders and disclosure, there is an explanatory statement which is given under section 42 subsection 2 and subsection 3 of the Companies Act 2013. A company shall make an offer or invitation to subscribe the securities through private placement unless the proposal has been previously approved by the board of directors and after getting the approval from the shareholders of the company by a special resolution for each an offer or the investors, provided in the explanatory statements annexed to a notice of shareholders approval, and the following disclosures are to be made. What are the explanation, what are the rules is covered up in this particular slide. The explanatory statement annexed to the notice of the shareholders approval, the following disclosures has to be made. A notice has to be sent to the shareholders and the approval has to be taken out in the annual general meeting. The particulars of the offer, including the date of passing the board's resolution, has to be mentioned. The kinds of securities offered through the private placement and which securities are being offered are to be mentioned. The basis or the justification for the price, including the premium if any, has to be mentioned with the explanatory statement. The offer or invitation is being made through private placement. The explanatory statement should also disclose the following information: that the name and address of the valuer who had valued that particular shares, who performed the valuation, his notes, his address, his qualifications to be mentioned, the amount which the company intends to raise by the way of such securities through private placement has to be mentioned, the material term for raising such securities, the proposed time, the schedule, the purpose or the object of the offer, and the contribution being made by the promoters or the directors either as a part of the offer or separately in furtherance objects of the principal terms of the asset change as the securities. The following rules are not applied under Rule 14 subpart 1. In case of offer or invitation for non-convertible debentures, this particular rule does not apply. Where the proposed amount to be raised does not exceed the limit as specified under section 180 subsection 1 subsection C, and such cases the board resolution is not been given under section 179 subsection 3 and subsection C of the Companies Act. In such cases the Rule 14 will not be applied, provided that in such case of offer or invitation of the offer for the non-convertible debentures, this rule won't be applicable. The Rule 14 subpart 1 shall not apply when there is a limit exceeds the time which has been given under section 180 subsection 1 and subsection C. It shall be sufficient that the company passes a previous special resolution. In such cases also, it is not applicable for raising the capitals through the private placement. Once in a year for all the offer, all the invitation and such debentures during that particular year, there should be an approval taken out in the annual general meeting. Rule 14, subpart 2. The purpose of rule section 42 subsection 2, which deals with the private placement and offer or invitation to subscribe the securities under private placement shall not be made to a person more than 200 in the aggregate in a financial year, provided that offer or invitation to an offer may be made through the qualified institutional buyer or the employees of the company under ESOP scheme as per the section 62 subsection 1 subsection C shall not be considered while calculating the limit of 200 persons. That means qualified institutional buyers are not included while counting out the number of 200. Rule 14 subpart 2. The explanation given under this is that the restriction aforesaid, which has been given on the previous slide, would be reckoned individually for each kind of securities, that is equity shares, preference shares or the debentures. Rule 14 Part 3. A private placement offer cum application letter should be in the form of application in the form of PAS 4. The number of that particular form is PAS 4. Serially numbered and addressed specifically to the person to whom this particular offer has been given, and should be either made through written form or through the electronic form or through the email form, and should be made 30 days before passing such type of offer letter, and same should be informed to the ROC. And the section which is there under this particular format is section 42 subsection 3. Rule 14 part 3, and private placement offer cum application letter should be provided to that particular person whose address has been given and that particular person is staying in that premises more than 182 days in India, and should be applied through an application form, and he should apply through an application form which has been issued by the company. And if that particular person does not conform to that condition, then in such cases the private placement offer letter is not being issued or given, or it should be withdrawn, and that would make them invalid application. Rule 14 part 4. The company shall maintain a complete record of the private placement offer letter in the form of PAS 5. The form number. Rule 14 part 5. The payment to be made for the subscription to the bank account of the person subscribing to such particular offer in the bank account and whereby has been received. That particular details IFSC code has to be given, and in such cases the person who is the investor will buy that particular offer, provided the money is payable on the subscription of the securities to be held in the joint holders. If it is held by joint holders more than one, shall be paid from the bank account of the person whose name appears first in the application. It means that if there are two persons who are jointly owning or wants to buy that securities through private placement offer letter, then the account holder's first name which is there jointly, in that case through his account only the money should be transferred. Rule 14 part 6. A return of allotment of the securities under section 42 shall be filed with the registrar of the companies within 15 days of allotment in the form of PAS 3. The form number is called as PAS 3, and the fee should be paid provided to the Companies Act and the rules made in, and the time and when the rules have been changing, that amount has to be paid to the ROC also. And the complete list of the allottees should be given, each and every details to the ROC. The details which is mandatory is that the name and address and the permanent account number, the PAN number of that particular investors, the email ID of the security holder, the class of the securities which are being held, the date of allotment of the security, the number of securities which are held, nominal value, amount paid in such securities, and the particular of the consultation received if the securities were issued for other than cash. Rule 14 part 7 deals with non-applicability of the Rule 14 part 2. The provisions of the Rule 14 part 2 shall not applicable to the NBFC, non-banking financial companies, which are registered under the Reserve Bank of India Act 1934 and the housing finance companies which are registered under the National Bank Housing Bank under the National Housing Bank Act 1986, if they complying with the regulation made by the Reserve Bank of India or National Housing Bank in respect of the offer, the invitation to be issued to the private placement offer letter, and they should also get the approval from the ROC. So those companies which are dealing with NBFC or those companies which are having that permission which has been granted by RBI or those national housing banking companies, if they are getting the permission from that particular act and the permission has been given by the regulatory authority, then only they can be investors in the companies. Rule 14, Part 8, a company shall issue a private placement offer letter, come an application letter only after the relevant special resolution which has been given by the shareholders or through the board of directors and has been filed with the registrars and with the register of companies, provided the private placement companies shall file with the register copy of the board resolution with respect to the approval which has been given under section 179 subsection 3 subsection C of the act. Thank you all. See, in this particular video there were many rules related to the obedience that the company has to obey before issuing the private placement offer letter and before giving that offer to the 200 select persons. Thank you from my side.